Did you know in New York it's law that you cannot greet your friends like this? Hey, how are you? What's up? Hey! Okay, that was too far. Please don't ever do that again. I'm gonna call the police on you now. You might well wonder, is this really a law? And good news, it's not. It's a myth that has been busted. But it might leave you wondering, what makes something a law? Could a rule as ludicrous as this count as a law? That's what we're going to find out in this video. The first person to tackle this question was John Austin, and he said that laws are basically commands, but specifically general commands that are issued by a sovereign and backed by threat of punishment or sanction. Let's break that down. First, commands must target general and not specific action. We cannot have a law that specifically states that you cannot walk on my garden, but we can have a law that's against trespassing in general. Next, commands must be issued by a sovereign. Austin defines sovereign as the person or the group of people who are habitually obeyed by the bulk of the population and do not habitually obey anyone else. He throws in the word habitually here not to be quirky and different, but because in modern times even our superiors have to sometimes answer to someone else.
You bow to no one.
Like a member of the legislature can find themselves before a judge. But we can pretty safely picture a sovereign to be the Prime Minister, the President, or the House of Commons. Finally, commands must be backed by a threat of punishment or sanction. Austin notes that a command without a threat is simply a wish, and nobody would follow a sovereign's mere wishes.
I order you to be quiet!
Order? Who does he think he is?
I am your king.
Well, I didn't vote for you.
We need that threat of punishment to make a command and therefore a law. And that was Austin's command theory. Now, what stands out about Austin's command theory and understanding of law is that moral judgments are excluded. At no point has morality come into the picture, which is to suggest that for Austin, a morally unjust law can still be considered a law. So when we might say lex injusta non est lex, an unjust law is no law at all, Austin does not care. If I became queen and made it law that you'd receive life imprisonment if you didn't subscribe to my YouTube channel, you'd probably go, that's unfair. Austin would go, this is his idea of legal positivism, which is to say law is what humans posit them to be. So Austin's like, who cares if it's moral or fair?
The law is the law. The boy must die.
All that matters is the source of the law, not its merits or its substance. If it follows the command theory, it's law. Henry VIII would have loved John Austin. Now, not only does Austin's command theory lack moral consideration, but it also fails to encapsulate all types of law. That is, not all laws are just commands that are backed by threat. Because what about voting laws or marriage law? These laws aren't commanding you to do something, they're empowering you to do something. So another philosopher sees this and goes, pause. John Austin doesn't have this all figured out. Let me clean this up a little bit. Hello, H.L.A. Hart. Hart argued that Austin oversimplified things, as not all types of legal rules can fall under one description like Austin attempted to do. So Hart introduced a better way of understanding law by splitting all types of legal rules into two different categories. First, there are primary rules, and these are like the rules that Austin had in mind, and also what most of us probably think about when we hear the word law. These are the laws which tell us what we must and mustn't do, like don't murder, don't steal, and do your taxes. And we are obligated to follow these laws.
What you command, we will obey.
That is, there are sanctions if we don't adhere and insistence that we do adhere. Hart believes that we take these laws seriously because they're social obligation. Following them is the socially acceptable thing to do, and by following them we can maintain social order.
Hey, a rule is a rule. And let's face it, without rules, there's chaos.
Then there are secondary rules. These tell us how to change, interpret, or apply primary rules, which is what Austin missed. Secondary rules encapsulate our legal empowerment, like rules on how to marry, how to sue, or perhaps even amend the Constitution. So, how to recognize what counts as valid law in the first place and whether we should follow it. This type of secondary rule, perhaps the most important, is what Hart calls the rule of recognition. The rule of recognition tells officials how to identify valid law. It's not a written rule, but a shared understanding. Something lawmakers, judges, and officials implicitly follow to recognize what counts as valid law. They may use this rule to decide things like, was this law passed by Congress and signed by the President? Is this a law that's in the Constitution, or is it a law that was issued by Parliament?
Wait, is it in the Constitution?
The rule of recognition basically acts as a legal system's internal compass. It ensures certainty and consistency so the system doesn't descend into chaos.
Anything were to happen to this box, the world as we know it would fall into chaos.
And if a rule has satisfied the rule of recognition, it's legally valid, even if it's immoral. Like Austin, Hart was a legal positivist. He believed law and morality are separate, and a law can be legally valid even if it's unjust. Here, Ronald Dworkin comes along and critiques Hart's positivism for this very reason.
The law is the law.
Dworkin did not see laws and morals as separate. To him, we cannot truly understand what law is without understanding its moral purpose. Things like fairness, justice, and individual rights should guide how judges interpret law. He called this approach to law legal interpretivism. We interpret and apply the law in a way that reflects our moral principles. The famous example that Dworkin cites is Riggs versus Palmer in 1889. In this case, a man murdered his grandfather to inherit his grandfather's will. Simply put, the law at the time said that if someone was named in a will, they inherit. But the court ruled that he could not inherit after his crime, even though the statute did not explicitly forbid it. Dworkin pointed out that the judge relied on moral principles when making this court ruling, not written rule. And that's legal interpretivism. Legal interpretivism. So going back to the first law we mentioned, where it's illegal to do this in New York in greeting, would these philosophers think this ludicrous rule could really be considered a law?
Did you see that ludicrous display?
Austin would say, yeah, it's a general command, and if it was laid down by a sovereign with a threat of punishment or sanction, it's a law. It doesn't matter if it's silly. Hart would say, sure, as long as this rule follows the rule of recognition. That is, as long as it's a rule that's been backed by proper procedures, still applies, and hasn't been repealed. But Dworkin would probably raise an eyebrow. Yeah, this rule might exist, but it's a rule that seems to serve no moral legitimacy. It's outdated, it's absurd, and has no place in a system that's guided by fairness and justice. So while it could technically exist as a rule, it lacks that legal authority. So to quickly sum it all up, what is law? For Austin, law is a general command issued by a sovereign backed by a threat of punishment or sanction. For Hart, law is a system of rules, where some tell us what to do, and others tell us how to change, create, or recognize valid laws. And for Dworkin, law isn't just rules, it includes moral principles. So there's that. If you haven't fallen asleep yet, congratulations, and I'll see you in the next video. Bye! That's stupid.